Welcome to our second lecture on the module concerning regulation of employment. Let's go ahead and begin. We've covered in the first lecture a general introduction to employment law, and we discussed the differences between employees and independent contractors. We also talked about why this distinction matters. Another topic that's not listed here, which we did talk about, was at-will employment, a topic that we will revisit many, many times over the course of this semester. The rest of this lecture today, we're going to cover the remaining topics. And so let's get started. I'm going to flip over to where we start talking about temporary and leased employees on slide 47. So again, all these slides up to this point are covered in the first lecture. And here we go. So our issue that we're going to be exploring in this section is, does joint liability exist with temporary workers? And probably two questions occur to you when you see this title. Number one, what the heck is joint liability? Is that a good thing? Is it a bad thing? What do I need to think about that thing, and what is it? Then the other issue is, what is a temporary employee or temporary worker? That may be a little bit more intuitive, but we'll explore both of those issues, and of course we'll also answer this question. So let's get started. So what is a temporary, oftentimes called a contingent worker? Well, you can see we have the term in red, and so we know this is one of these definitional terms that you'll want to put in your list of terms that you're working on over the course of the semester. A contingent worker or a temporary worker is one whose job with an employer is temporary, is sporadic, or differs in any way from the norm of full-time employment. This could even include part-time workers, although a lot of times part-time workers aren't treated as contingent workers. But let's say that I am someone who is on an on-call status. I work when somebody calls in sick, or I work when it's the busy time of the year. Those types of situations, we'd call me a contingent worker. And as you can see in the terminology, you can see how that plays out logically. There's a contingent, or something has to happen before I am called to work. So there's a question mark about when I'm going to be called, and that's where we get the concept of contingent workers. And we can see how temporary workers fit nicely into that category. They're not going to be here forever. They're on a temporary basis, so there's some contingent, there's some set of facts that we're looking for. Imagine for a second that I'm a temporary worker and I've been called into work for the next 8 weeks while Sally is recovering from childbirth. Well, my employment is contingent upon the fact that Sally is unavailable to work. Or let's say I go to work for Macy's for the Christmas holidays. I start the week before Thanksgiving, and I will no longer be employed the week after Christmas. Well, my employment is contingent upon the holiday season. Those are examples of contingent situations. Now let's explore this term, joint employers. We've kind of figured out contingent or temporary employers up here. So going back to our question, temporary employers, we kind of know what's going on there, but now we've got to think about, what do we mean by joint liability? What is a joint employer? And again, a joint employer is going to have that joint liability. Well, it needs to have two things going on. Well, I guess the first thing, before we even get to what we need to have at least two entities involved. If there's only one entity involved, there's no joint employment, right? Joint implies two or more, right? So we need to have two entities that have something kind of like an employment relationship. For example, historically, I'm going to go back in ancient days, kind of even before my time, but maybe a little bit at my time, was that there was a secretarial temp business. I think it still exists. At the time, it was called Kelly Girls. A little bit of a sexist term, but nevertheless, that was the term that was used. Anyway, these were primarily women who would work for Kelly Girls, and they would be called in when a secretary, receptionist, or other office worker was absent, maybe for vacation, maybe because of illness, maybe because of turnover, all those reasons. And so the Kelly Girl would come in, maybe for a day, maybe for several weeks. It would vary. And in that situation, the Kelly Girl was actually in some sense, working for two different entities. She was working for Kelly Girls. In fact, her actual paycheck came from Kelly Girls. And then the day-to-day functions would be in this other place of employment. Maybe she was working for ABC Construction, and maybe she was the receptionist for ABC Construction for a period of 12 days, we'll say. Well, she would do the functions that her ABC Construction supervisor would tell her to do, but her actual paycheck would come from Kelly Girls. What would happen is ABC Construction would pay Kelly Girls maybe $15 an hour, and Kelly Girls would keep maybe 5 of those $10 an hour as their kind of handling middleman type cost, and then they would pay the Kelly girl, the receptionist, $10 an hour. And Kelly Girls would be responsible for doing all of the appropriate withholdings. And from a legal standpoint, we would think of Kelly Girls as being the employer of, we'll call her Susan. Susan, the receptionist, the temporary receptionist. But you can see how ABC Construction has a relationship with Susan, the temporary receptionist. And so the issue is, what are we going to call that? And one possibility is we're going to call ABC Construction a joint employer. We know Kelly Girls is an employer. That's indisputable. But there's an issue about whether this other entity is as well. So let's consider these two requirements that have to exist in order for the company that has hired the temp business and to place Susan in is going to be considered a joint employer. The two separate businesses hire or control the same employee, and each business has a relationship with the other business. Well, we can see in the example that I gave that certainly Susan has a joint employer, because the ABC Construction is going to control the tasks that Susan does. They'll tell her, this is how you should greet people who come to the reception area. This is how you should answer the phone. This is the filing tasks you ought to do. This is how our filing system is set up. All of those things are matters of control. They might tell Susan when to come to work, when to leave, when her breaks are, where she can have lunch, what the dress code is, all of that kind of stuff. Clearly, ABC Construction is going to be controlling the specifics of Susan's job performance. You may want to think back to the 3 tests we talked about that distinguish an employee from an independent contractor. We talked about the economics realities tests. We talked about the control tests, the common law agency test, which has to do with control. Well, you can see here, ABC Construction Company is definitely treating Susan like an employee under that common law test, also the 20 factors test, very likely. And certainly Kelly Girls is hiring Susan. And so one is hiring, one is controlling. So we look like we've satisfied the first requirement for joint employer status. The second one, though, is also satisfied, and that is that Kelly Girl and ABC Construction absolutely do have a relationship. Basically, ABC Construction has hired Kelly Girl and is paying Kelly Girl for the providing of Susan, the receptionist. So under this situation, joint employer status is clearly satisfied. Now, it's pretty inevitable in the example that I use that you're going to have joint employer status, but this isn't good news. I mean, this is not something that ABC Construction looks at and goes, yippee, we're the joint employer, Susan, great news, we're so thrilled. No, it's not a good thing, because once you become the employer of some person doing work for you, all of those things that we talked about in our last lecture start playing out. You have to worry about Title VII issues, for example. Things along those lines that you don't have to worry about with independent contractors become an issue. So let's say that somebody in the office starts sexually harassing Susan. Well, guess what? Susan's an employee. ABC Construction could be sued for sexual harassment. Kelly Girls could also be sued for sexual harassment. So in a perfect world, ABC Construction doesn't want to be a joint employer. Probably can't avoid it, but it's not a good outcome for them. So going back to our slide here, does joint liability exist with temporary workers? In the example that I gave with Kelly Girls, Probably so. Of course, many times temporary workers are hired directly from the business. In other words, let's say that Susan was going to replace somebody who was expected to be out of work for 16 weeks. Well, ABC Construction might decide to just go out and hire somebody on its own without using any kind of temporary service. In that situation, there is no secondary business. And so because there are no two businesses, there isn't any joint employer situation. ABC Construction is the sole employer. It has all of the advantages and disadvantages of the employment relationship. Okay, so we talked about the Microsoft permatemps before, people who are called temporaries, but they're temporaries like forever. And that is super problematic. You don't want to be in that situation. Even if somebody is kind of contingent and they're not working every day, things like that should not go on forever. A good rule of thumb is to end those type of relations certainly at the 6-month point, probably even before then, and just no way at all should you extend it beyond the year point. So if you have somebody who's coming in 2 days a week or 1 day a week, or it's flexible, whatever, you need to have a date that says, okay, this can go on only for 90 days. And at that point, we're going to have to hire somebody else. Now, maybe after 90 days, we can bring that other person back. If there's breaks in the system, then the temporary status, we're having 2 temporary statuses versus 1 super long temporary status. And you can see how that becomes an oxymoron. I mean, you can be temporary or you can be permanent, but you can't be both. And pretending that the person is just a presentation that just isn't logical, isn't sensible. And so one of the reasons, of course, Microsoft did this with the temps and the independent contractors is to avoid having to pay employment benefits to these folks, saying, hey, well, you're not really in the category of people eligible for them. Well, if you keep people on indefinitely, guess what? They do become eligible for those benefits. And that's why HR departments routinely say, okay, we don't care how awesome this person is. After 90 days or maybe 6 months, you either have to end the relationship or you have to hire them. If they're that great, go ahead and hire them. But if you don't want to do that, you need to cut the ties. Bring them back in 6 months if you want to, but you need to have a break. Let's go through a couple scenarios here. Okay, so we have this Emperor Penguin Industries. It employs part-time workers through a staffing company. So this is the Kelly Girls scenario. Emperor's manager asks the firm, the staffing firm, to replace one of its part-time workers with someone from a different race, and the staffing department does so. So let's say that the person that was initially hired or initially put into place at Penguin was African American. The manager says, we don't want this African American worker, we want somebody who is Caucasian, for example. The staffing firm agrees to make this change and does make the change. Emperor will be liable because it's discriminating against people based upon their race. Emperor can't avoid liability by asking somebody else to break the law for it. That's not how the law works. If I tell someone to break the law and that person breaks the law, well, that person is clearly guilty of breaking the law, but I'm also clearly guilty of breaking the law. So Emperor is going to be liable under Title VII, but also the staffing company is going to be liable under Title VII. So hopefully the staffing company is going to say no. No, we refuse to do that. If you have a performance issue with that part-time worker, then we can talk about that and address that, but we can't consider the race or the gender of our employees or your joint employees under those circumstances. So again, both of the entities are required to comply with employment law. Let's look at the next one. Hippopotamus Supermarket hires a temporary salesperson through a staffing firm. So again, we're back to the Kelly Girl scenario. Another company like this is called Manpower, but there's lots of them. Those are just 2 examples. The salesperson is on the payroll of the staffing firm, so it's not actually a record of being an employee for Hippopotamus Supermarket. After 3 months, the manager of the supermarket asks the staffing firm to replace the salesman with someone of a different race. The replaced salesman or salesperson decides to file a claim of racial discrimination. The supermarket can be held liable for discrimination under that situation, and so can the staffing firm. So again, similar facts, same outcome. The bottom line is Title VII and really all of the laws prohibit staffing firms from discriminating against its workers in its assignments and opportunities. And it's not just the termination situation, but it's the initial assignment. So if a company says, we only want people of this gender or this race or whatever that particular characteristic is, the staffing firm can't comply with that. I mean, they have to say, no, we'll have to send you all the qualified people. And so if that's a deal breaker, then that's going to be a deal breaker. Let's look at our next issue. Is this worker an employee instead of a student, intern, volunteer, or partner? So we've previously considered, was this person an employee or an independent contractor? But there's actually a few other choices out there. Someone might not be an employee or an independent contract. They might be something that's, at least in this case with these first three choices, that is more like an unpaid status. Doing something for not financial remuneration, maybe for some other type of reward system. And a partner has to do with, is this person an employee or an owner of the business? So we'll look about how these distinctions exist and the significance of those. I'm not going to focus on the NLRB because there's been a lot of conflict in this area. What the National Labor Relations Board has done has kind of gone both ways, and right now it's looking like many times positions that are maybe in the past have been considered students or interns or learning positions. The NLRB is now looking at it more likely to find it something that can be organized and that more closely fits into the employee category. So, but this is a moving target, and if you decide to work in an industry like this, you'll want to be keep abreast of the law because, as I say, there's just a lot of give and take here. Recently, the Harvard University's graduate students were organized, and so graduate assistants can be organized, probably again until the rules change. The NLRB, by the way, National Labor Relations Board, it is one of those agencies, kind of like the EEOC. There's some important differences, but it's somewhat similar. It is one of the more political of the agencies that you'll be dealing with as a employment law expert. It is likely to switch as we have a president of a different party. So, for example, when the Democrats have when the president is of the Democratic Party, he or she has the ability to appoint or to maintain 3 of the 5 board members. When a Republican is elected president, then he or she appoints or makes sure there's 3 of the 5 positions. And most of the votes on the NLRB go 3-2. And so all of the Republicans vote together and all the Democrats vote together. So what can happen, and honestly what does happen not infrequently, is that the law will switch. It was ruled one way the day before the election, then another way the day after the election. The most famous example of that is wine garden rights. That's something we're not going to talk about in this course, but if you dive very far into this area of the law, you'll learn about wine garden rights, and you'll see how, we have a president of another party, probably this is going to flip. And that causes a lot of challenges, honestly, for employers, because from the time that a charge is filed in this area of the law until it gets to the board can be several years. Well, none of us have a crystal ball. We don't know in 3 or 4 or 5 years who the president is going to be and what party he or she may have. And so what the current law is, given the identity of the current president, may be different when the case under which we are functioning goes up before the NLRB. So lots of interesting, tricky political aspects to that. But I will tell you, generally, students and interns who are working need to be paid. There's a lot of abuse in this area. A lot of companies have cut corners and have permitted the use of unpaid internships. Almost always those arrangements are unlawful, and there are very, very significant penalties for companies who break those rules. Not only are they unlawful, but they are also in my opinion, in most cases, immoral. We're taking advantage of people who are usually not having very many assets of their own. And it causes some additional problems because these internships can be very helpful in the advancement of careers, but people who are genuinely without a lot of resources aren't able to avail themselves of this because they need a job in which they can earn money. So people who are from more financially successful families who can, have some wherewithal through their parents perhaps, are able to take these opportunities and then kind of fast forward their career. And so it becomes really something that undermines some of the diversity initiatives that employers happen to say that they would like to advance, but perhaps they aren't as focused on it. So the bottom line of it is, if you're not paying somebody and they're doing something for you, probably 95% of the time or more, there's a violation of law. You need to pay folks at least a minimum wage. Now, once you pay somebody a minimum wage, you're okay for the most part. You're in pretty safe ground at that point, even if this job under other circumstances would be more highly paid. As long as you have both men and women doing the internship, you can pretty much rest easy that you're going to be in pretty good shape. If you are, though, not paying folks at least minimum wage, it's very difficult because if you have the interns there and they're doing really anything of value that helps your organization, they have to be paid. Now, if they really are shadowing, let's say you happen to allow some interns to come into your facility and all they do is watch, then that's okay because they're not doing anything that's helping your business. But if they are, while they're watching, if they're carrying someone's briefcase or they're making the coffee or they're taking notes or they're making comments to maybe make some documents better, guess what? Even if it's a relatively small part of what their job tasks are, they're giving some value. Oops, you've tripped the wire at that point and you need to be paying them, and you need to be paying them at least minimum wage. Volunteers, it's really difficult to have someone called a volunteer in a for-profit business. It just doesn't make sense. Obviously, if it's a nonprofit business, it makes a lot more sense. And you can't have wage workers who also work as volunteers. If they are doing stuff for your business and you are paying them sometimes, anytime they're doing something for your business, they need to be paid. Let's talk about partners. This is a little bit of an interesting area. As I said before, we think about partners as not being employees because they own the business. And the nature of an employee is somebody who is working for somebody else. Well, if you're a partner, you're working for yourself. You are the employer and in some sense the employee. So it doesn't really make sense to say all these employment laws ought to apply to the partners. And that's true generally. And you can see in this statement, partners, officers of the company, board members of the company, major shareholders are generally not considered employees because they are the owners of the business. Having said that, there is at least one big case in this area that may carved out an exception to that, and that is in the case of a law firm. Some law firms are very, very large. They can have hundreds and hundreds of attorneys working there. And one law firm had that process. They had hundreds of attorneys, maybe even over 1,000 attorneys, and then they had well over 100 partners. And some of the partners wielded real power, and some of the partners didn't. The terminology that they used for these individuals were partners, but honestly, they had very little say in the organization of the business. They weren't really able to vote on things, and the amount of profits they got was very, very small. And so the EOC established that while the term partner was being used to describe the relationship, these individuals are more like employees. Remember in the last lecture we talked about the duck test? Does it quack? Does it flap its wings? It's sounding like a duck. Well, this is what the EOC concluded about these particular individuals. What the EOC was not saying is no partners ever are going to be excluded from the definition of employees. Certainly many times partners will be excluded, even partners in those large operations. But when the term itself, the name itself is not going to be definitive. Let's consider the situation of a person as an applicant. When does a person cross the line from being a stranger to being an applicant? I guess the first thing to think about before we kind of dive into this question is, well, why do we care? I mean, what does it matter with the terminology that we use here? Well, once somebody becomes an applicant, many of the protections that apply in the employment area apply to this person, even though this person is not an employee yet. So for example, let's say Bob applies for a job at ABC Construction Company. We'll say that Bob has a disability. ABC Construction Company considers Bob's candidacy and says, no, Bob, we don't want you because you're in a wheelchair. Well, that possibly is an example of disability discrimination. But let's say that Bob, in the privacy of his own house, one morning wakes up and thinks, you know what, I'd like to work for ABC Construction. But he never tells anybody that he wants to work for ABC Construction. ABC Construction doesn't even know Bob. And so, naturally, ABC Construction doesn't hire Bob. Under those circumstances, obviously, ABC Construction didn't discriminate against Bob because Bob never attained the status of applicant. So moving from, just person in the general population to applicant is a big legal distinction. And so let's talk about how we know when somebody crosses that line. Once upon a time, this wasn't a really hard line to know because, you know what, a person sent a resume to a business or stopped by and left off a job application or talked to a manager in the facility. It was pretty obvious when they were saying, I'm interested, please consider me. And once that conversation happened, then we all pretty much knew, okay, this person has moved to the applicant category. But nowadays, especially with the internet, it becomes a little bit more foggy. For example, let's say I send an email to an employer and say, hey, I'm just interested in if y'all have any openings, let me know. But I don't express an interest in a particular opening. Well, this employer might have 50 different openings. I may not even explain in my inquiry what my skill set is, so the employer is really not in a position to know whether I'm a good fit or not. Would it really make sense to consider me an applicant for all 50 of those positions? Probably not. Another thing that can happen is that I can post my resume on some kind of board, maybe a monster.com board or an Indeed board or something like that. And maybe the employer sees all that data, maybe the employer doesn't see all that data. But the employer hasn't actually received that data. It's not been that direct contact between the potential employee and the employer. It's on this third-party location. So under those circumstances, probably that person isn't an applicant yet. So when we're looking at the definition of applicant, here are some things we might want to think about. The person submits an expression of interest reflecting basic qualifications for a posted job. So that's different than that first example where I just said, hey, any position, no specificity, and no discussion of my qualifications. Then our next requirement is the employer considers that person for employment in a particular position. Now, if I were to send that broad-based, hey, if you've got anything, think about me, most likely no one will even bother to do anything with that candidacy because it's just too much work. Maybe they have enough candidates already for the 50 positions. It's going to be a lot of work for the potential employer to reach back to me and say, well, what are your qualifications? These are the jobs we have. Which ones seem interesting to you? But if they don't ever do anything with it, they haven't really considered that applicant. So that threshold hasn't been crossed. And finally, we also need to be an applicant. We need the applicant himself to not remove himself from consideration or signify disinterest. So if I say, after a couple weeks, you know what, I found another job across town, don't consider me any further, then obviously the potential employer appropriately stops considering the candidate at that point. And so that person moves out of applicant category to just member of the general population. So it's not automatic just because I might want to work someplace that I'm automatically a candidate. It's important to consider in a little bit more depth before you make that judgment. Here we have a scenario to think about. After graduating from college, Mary sends an email with her resume to this particular company. In her email, she was only inquiring about an entry-level position. So she doesn't even specify what she wants. Does she want something in sales? Does she want a receptionist job? Does she want something in the manufacturing side of the business? Does she want to be in marketing? Just tons of different entry-level positions that might exist. After she submits this inquiry, she finds out that two of her classmates of a different race than she is. We'll say that Mary is Caucasian, and one of the individuals hired is Asian and one's African American. They're hired. So Mary's pretty steamed at this point. She didn't get an interview, and so she files a charge. Unfortunately for Mary, her inquiry is probably too vague to qualify as an applicant. If she had said, for the entry-level position of junior marketing manager or the entry-level position of warehouse supervisor, that might have been something that could have moved her into the applicant category. Let's consider this one. Is a business an employer? Another word for this might be a principal. This is, we've looked at it from the perspective of the employee. Is the employee or the worker? Is the worker an employee or an independent contractor? Or maybe he's a volunteer or a student or intern or partner. We've been looking at it from an employee-centric basis, but you know what? There's two sides to this equation. Let's consider it from the perspective of the business, because sometimes the business might not meet the definition of an employer. Let's consider that. Obviously, the employer has to have employer status before it's going to be liable under most of these statutes. So imagine for a second that I am the McKinney SPCA and you volunteer to help at the SPCA because you love animals. And you come to work there, and while you're taking care of one of the dogs or some of the other animals, you get bitten. You want to file workers' compensation benefits or something along those lines, and you want to be you want your status to be that of an employee, and you want the SPCA to be considered the employer. But the SPCA might very reasonably say, we weren't your employer. Maybe we were employers of some other people, because I'm sure the SPCA has some staff. So the employer status, if it exists, is another part of that equation. Let's look at, and again, so all of these statutes here, and you can see Title VII is our second one. All of these statutes have some type of definition of employer. So we have in most of these statutes a definition of employee, we have another definition of employer. Let's look at some of those aspects. Okay, so sometimes an employer or an entity that would ordinarily in everyday conversation think of as an employer, the statute excludes because of the particular industry it's in. So or some other characteristic about it. So for example, private membership clubs, think country clubs, are oftentimes excluded from the definition of employer. So for example, country clubs maybe restrict its memberships and its employees to certain classes of individuals. Not defending it, but that might be the case. That's probably going to be legally okay. Maybe not morally okay, but still could be legally okay, because private membership clubs are usually not going to be considered employers, even though they probably have employees on their staff, people who are going to be bussing the tables, cleaning the facility, cooking the food, that type of thing. Another category that isn't going to qualify are Indian tribes. Many Indian tribes run businesses. They may have social welfare programs for their tribe-enrolled members. They may, in some instances, even run businesses such as casinos or things along those lines. And usually they do not have to comply with at least certain aspects of the employment laws. And then corporations that are fully owned by the U.S. government, Title VII doesn't apply to. Probably, though, these first two are the bigger areas of interest here when we're talking about Title VII. The Age Discrimination and Employment Act is not actually part of Title VII. Title VII provides protection for employees based upon their race, their color, their national origin, their religion, and their gender. The Age Discrimination Employment Act obviously provides protection for age. So this is a new category. We don't have age in Title VII. We had to wait a couple years longer after Title VII was passed before we had the Age Discrimination Employment Act, and that provided protection for people based upon age. I'll give you more granularity about that later on. But you can see it includes two of the three protections. It also excludes, or excuse me, it does not exclude Indian tribes, and it does not exclude private membership clubs. So an Indian tribe can't discriminate against people based upon their age, even though they can prefer, for example, Native Americans as employees. But let's say there's a Native American who is 50 and a Native American who is 30. Well, the Indian tribe can't prefer the Native American who is 30 simply because he happens to be younger than the Native American who's 50. We have another statute, the Fair Labor Standards Act. We talked about that before. This is the one that has to do with minimum wage and child labor laws. It covers employees if their work regularly involves them in commerce between states. So if you have an employer, this says employees obviously, but we're looking at it from the perspective of employers for our purposes. If you have an employer who's really and truly just based in one state, maybe it's a farm that has a few workers, and they sell maybe at the local farmers market. And so there really is very little interstate activity that this particular farm does. Then the Fair Labor Standards Act won't apply to the workers there. So the workers would have to rely upon state law in those circumstances. There are relatively few employers that are going to be excluded because of this definition, because even very small operations actually do end up being involved in a fair amount of interstate commerce, and so it takes a pretty unusual set of circumstances for this for this rule to exclude a particular employer. Now we're going to look at it from a different lens. We've talked before about employers that are excluded from the definition because of the particular industry or identity that they have, but honestly, that's not the most common characteristic that excludes employers. Most employers that aren't covered by the discrimination statutes are excluded because of the number of employees that they have. And the two that we're going to focus on right here is 15 and 20. There are other thresholds. 50 is another fairly big one. 4 is another one that we'll talk about from time to time. But now we're just going to focus on the 15 and the 20. Title VII applies when a particular employer has at least 15 employees. The equation to calculate that is a little bit more involved, but the big takeaway is 15 employees. So if I only have 12, Title VII isn't going to apply. Under those circumstances, that particular employer can discriminate based upon race or sex or whatever the characteristic is. Probably not a good business model to do so, but it's not against the law. Now, some states have lower thresholds than 15, and so some states would have additional protections in those cases. Generally speaking, Texas doesn't have additional protections. But once you reach to this 15 number, then you can't discriminate on those bases going forward under Title VII. The Age Discrimination Act, ADIA, that's what we typically call this. So this is Title VII. This is Americans with Disabilities Act, the ADA. That has the level of 15. Typically, we call this statute Title VII, and we call the Americans with Disabilities Act the ADA. The Age Discrimination Employment Act is oftentimes called ADIA or ADEA. It's just a mouthful to say all of this. The threshold here is 20 employees or more. Now you may wonder, why didn't they go with 15 like the other statutes? Good question. I don't have maybe the perfect answer for that, except to say that the composition of the Congress had changed a little bit from one passage of one statute to another. And the development of these statutes are definitely a compromise situation. Liberals in the legislature and conservatives in the legislature do a little bit of horse trading back and forth. And I'm sure that in exchange for the number going up from 15 to 20, the conservatives needed to give a little bit more in another area. And so exactly where that compromise is going to vary. So again, 15 and 20 are the big dates here. 15 for Title VII and ADA, 20 for ADIA. Now, not all of these statutes have these levels, though. These are two very common ones, but we also have protections under the Civil Rights Act of 1966 that there is no minimum number of employees. The first one you hire, this statute applies to. And we have the Civil Rights Act of 1991, which amended the Civil Rights Act of 1866. And it is designed to cover actions by employee after the contract has been formed, including discrimination during employment or termination. So this used to just apply when you were entering the contract, and there was no particular number. But the Civil Rights Act of 1991 significantly broadened this. So this became very similar to Title VII. Covering many of the same characteristics, but instead of needing to have 15 employees, only one employee was all that you needed. And so as a result, this has really changed the landscape for discrimination cases. So going back to my example of only having 12 employees, well, if somebody wants to file an age case against me with only 12 employees, they're not going to be able to do it under Title VII, but they will be able to do it under the amendments the Civil Rights Act of 1991, because race is one of those covered categories under this law. It won't apply, though. I can't be sued for sex discrimination under this particular statute, so the 15 would still be in effect under those circumstances. So there's lots of details there. Okay, let's consider a scenario. So we have this painting company. They have 2 supervisors. Let's see if I can get my... Goodness gracious, I don't know what I'm doing wrong here. Okay, so we have 2 supervisors, 7 painters, so we have 9, 4 helpers, so we have 13, 2 schedulers, that's 15, 2 carpenters, that's 17, and 1 office worker, that's 18. So we have a total of 18 employees. They're all permanent workers of the company, and they each work 8 hours a day. Because we have 18, they will have crossed the 15 employee threshold that we covered right here. They have more than 15, which means this law applies, and the Americans Disabilities Act law applies. But guess what? This statute is not going to apply because they did not reach the 20 employee threshold. We've already talked about responde et superior and the whole agency idea, but let's just do a bit of a refresher. And that is, this is the general rule that we discussed when we were talking about vicarious liability. Generally, employers are legally responsible for the actions of their employees while the employees are acting under this within the scope of their employment. And we call that doctrine responde et superior, which is a subcategory under the larger category of vicarious liability. We have the term agent, which in this case is just another word for employee. And the definition of agent is a person who is authorized to act for another, in this case the principal or the employer, through employment by contract or apparent authority. Then we have the principal, that's another word for the employer, the person or entity. When we say person in the law, we don't necessarily mean human being. In everyday conversation, if I say person, you think I mean somebody with 2 arms and 2 legs, right? I mean, that's what we think when we think person. But under the law, when we use the term person, it has a broader meaning. Yes, it can mean human being, but it can also mean corporation, partnership, limited liability company, lots of different entities. And so think about it a little bit broader than we would use in everyday conversation. So the employer, who is the person hiring and directing employees, again, the agents that we talked about here, to perform the principal's business. And then agency is the term for this relationship. A consensual relationship where one party, the principal, this guy right here, grants authority for another party, this guy, the agent, to act on behalf of or under the control of the principal to deal with a third party. So this is when we have this agency relationship, this is when this rule kicks in. Let's look at the scenario. Mary works as a salesperson at a greenhouse. While demonstrating to a customer how to use a hedge trimmer, she accidentally cuts the customer in the arm, requiring a visit to the hospital and several stitches. Under those circumstances, Mary is obviously liable for her own actions. Mary will always be liable for the stuff she does, obviously. But you know what? Her employer is also liable under the theory of vicarious liability, and more specifically, the theory of respondeat superior. So the customer can sue both Mary and Bob's greenhouse. Bob's greenhouse is going to have the deeper pocket, the more resources. So if a verdict is rendered on behalf in favor of the customer, then the customer is probably going to collect the judgment against Bob's greenhouse. Then Bob, if it so chooses, can seek to recover the amount of money it had to pay against Mary individually. As we talked about it before, it's probably not economically worth Bob's greenhouse's time to try to collect against Mary, since she has a relatively low earning job, and so she probably doesn't have the kind of assets that would make sense for Bob to try to seek a recovery from her. So let's consider the limits of this doctrine of respondeat superior, because it doesn't mean that every single thing I do in life as an employee of Collin College could be responsible for. Let's say that over the Christmas holidays or spring break, I go down to Galveston and I'm on the beach driving around on Galveston Island, and I'm in a car accident. I'm not doing college business. Obviously, Collin College isn't going to be responsible for that. So just because I am Collin College's employee doesn't mean every single thing I do is going to be attributable to Collin College. The situation in which the employer is going to be responsible when there is actual or apparent authority to do that particular action. Going back to my example before, when I was the Target cashier, I was there with the apparent and actual authority of Target to be there. I had access to the cash register. I had a name tag. Maybe I even had the vest that Target employees wear. But when Cynthia Groover is on Galveston Island enjoying a vacation from Collin College, there is no apparent or actual authority that Collin has conferred to me to be there. Now, if I am on Galveston Island representing Collin College at a conference or something like that, yeah, maybe there is an argument that I have actual or apparent authority under those circumstances. Let's consider this paragraph right here. Employment law based upon agency principles imposes a duty on an employee to act as authorized. So I'm supposed to follow the instructions that I'm getting from my supervisor. If the employee exceeds his or her authority while acting within the scope of the employment, the employer is liable for damages or loss incurred by third parties, while the employee remains liable, of course, for the employer. So sometimes you might have a situation where an employee is told, don't do this, but the employee goes ahead and does it anyway. The example of me punching someone in the nose. I, as the Target cashier, clearly exceeded my authority when I punched Bob, the customer, in the nose. But still, Target is going to be responsible for that because I was in my mode of being the Target employee at that particular time. Let's consider this scenario. Mary is an independent contractor, so she's not an employee, and she works for Bob's operating business. While driving to a meeting at Bob's headquarters, Mary causes a car accident in which a cab driver is hurt. Mary was talking to one of the managers at Bob over the phone while, I guess, she was driving on that day. Therefore, Bob has vicarious liability. So she was, even though she's an independent contractor, so it's less of an automatic liability situation, she was certainly going to Bob's at the time, and she was interacting in a professional manner, talking about the work at the time that she had the accident. And so Bob can absolutely have vicarious liability even though Mary is an independent contractor. I like to give this example because sometimes people get really fixated on the idea of employee means vicarious liability. Independent contractor means no vicarious liability. That's one of the factors that's in play, but it's certainly not an either or in every single circumstance. Okay, let's consider the Ellerth case. This is a really, really important case that we will talk about at great length later on in this course, because this is a huge, huge important case in the sexual harassment area. We're thinking about it in a more narrow sense for this purpose, so I'm not really going to give a tremendous dive into all of the facts of the case. Let's consider the issue, because remember, when we're looking at cases, we're really looking at four things. We're going to look at the issue. What is the particular legal principle that the court is trying to figure out? Then we're going to look at the facts of the case. What happened? Who did what to who? So those are the first two things. So what is our issue? Can an employer be held vicariously liable? We know that term. We've already talked about that. To an employee, even though the employee did not suffer adverse, tangible job consequences. Now we're going to talk about the facts. So we have Kimberly Ellerth, and you can see this last name is the same that we have up here, right? So she is the plaintiff in this case. She quit her job as a salesperson for this particular company. Ah, look, Burlington Industries, the same name we see up here. So you can see this is an employment dispute. She claimed that she had been subjected to constant sexual harassment by her supervisor. So she quit because she was being sexually harassed. At least that's her explanation about the incident. In her lawsuit, she alleged situations where her supervisor made comments that could be construed as threats to deny her tangible job benefits. Maybe things like, sleep with me or I'll fire you. Sleep with me or I'll put you on that shift you don't want to be on. A short time after the last incident, Ellerth quit, and she explained at the time that she quit that she was quitting because of her supervisor's behavior. During her tenure at Burlington, however, she didn't inform anyone in authority about his conduct, the supervisor's conduct, even though she knew that her employer had a policy against sexual harassment. So she wasn't following the policy as it had been presented to her. So those are the facts of the case. So there's four things that we're looking for when we're looking at case. We're looking for what is the issue that's going to be decided. We're looking at what are the facts in play in this case. And the next thing we're looking at is the least important in many cases of the four things we're looking for. And that is, how did this case proceed through the court system? I'm not going to focus on this one just because it's not relevant to our process here. Sometimes the section is important, but most of the time, for our purposes, it has lesser importance. And now we're going to get to the holding. This is obviously the most important part. This tells us what the court decided and why the court decided. This provides the answer to our question that we started off with. So let's look at here. The court held that when a supervisor's sexual harassment culminates in a tangible employment action, such as dismissal, an undesirable reassignment, or an actionable hostile environment, the employer is vicariously liable, meaning the employer can't escape liability. Now, no employer, or virtually no employer, wants its supervisors to harass the employees. I mean, there's just no business reason for that. Just like Target didn't want me to punch Bob in the nose. But what the court here is saying is, you know what? You need to pick your employees pretty carefully. When they do a great job, you're going to reap the benefits of that. When they do a bad job, you're going to receive the negative consequences. And that's going to motivate you to be more careful about who you hire and who you retain. It's also going to motivate you to supervise more carefully and to train your folks better. And so when there is a tangible employment action, the word tangible means touchable, but here we're not using it in that sense. We're using it in the sense of you can point to a particular thing, an objective thing that has changed. An intangible action would be something like this. My coworkers kind of look at me a little bit weirdly now. Sally used to want to have lunch with me, and now she's always saying that she's going to not have lunch with me. She's going to eat with some other friends. but you can't point to a particular thing in the work environment that has changed. You know, my office location hasn't changed, my pay hasn't changed, my title hasn't changed. Once you see changes like that, those become tangible job actions. And when you have those, that's when you have this vicarious liability. Now, the plaintiff still has to prove the case, has to prove that there was sexual harassment, has to prove there was a tangible job action. But once all that stuff is proven, the employer can't get out of liability by simply saying, hey, we didn't want the supervisor to be a jerk and do all this stuff. No, the employer is going to be tied to that supervisor's action if we have the tangible employment action. It also held that employee who, so this part here is tangible job action equals vicarious liability. Let me just go ahead and flag that. Tangible job action. I guess that's not going to work either. Okay. But let's consider the situation of when there isn't tangible job action. That's our next category here. It also held that an employee who experienced sexual harassment but did not suffer adverse and tangible job action harm, in other words, they weren't denied a promotion, they weren't paid less, could still sometimes recover against an employer without showing the employer was negligent or at fault, but such liability is not automatic. So the vicarious liability is a possibility, but there's other things we have to consider. So let's go forward and see what those things might be. Okay, now we're going to talk about the idea of affirmative defense. This is huge, huge, huge in the law. It's not just big in employment law. This is something that you'll see really in every area of the law, whether it be criminal law, civil law, just really any category. So let's break it down in general terms what we mean by affirmative defense. I think we all know in most cases that the plaintiff, the person who's initiating the lawsuit, bears what we call the burden of proof. It has to come forward and present more evidence to persuade the jury that the plaintiff ought to win. We call this, in civil cases, usually the burden is called preponderance of the evidence. So if there's a literal tie, if the plaintiff is just as persuasive as the defendant, but not any more persuasive, so that the jury is honestly thinking, gosh, it could be either way. I mean, we're not leaning either way. We're not leaning toward the plaintiff. We're not leaning toward the defendant. So in the case of a complete tie, the tie goes to the defendant. Now, this is a really different standard than criminal law because we have beyond a reasonable doubt. So you could have a jury that is pretty darn persuaded the defendant is guilty, maybe 90% sure even, but there's still that reasonable doubt. It's not huge, but there's a little bit of a reasonable doubt. And so under those circumstances, the jury is supposed to acquit the defendant. But we don't have beyond a reasonable doubt in civil cases. We have preponderance of the evidence, and it's called the 50% plus case. It has to be just a little bit above 50%. So the plaintiff bears the burden of proof most of the time. But there is one situation in which the defendant bears the burden of proof in a civil case, and that's the affirmative defense category. So sometimes the plaintiff has proved its case, and now the defendant might come back and say, okay, you got us on that one. Oh, yeah, okay, we messed up. Okay, fine. But you know what? We still get to avoid liability because of this other thing that we haven't talked about yet. And so then the defendant has to prove that. And the defendant has that same burden of proof that the plaintiff has, a preponderance of evidence. In a true tie, if the defendant's bearing the burden of the affirmative defense and the jury says, well, gosh, you know, maybe the affirmative defense exists, maybe it doesn't, we just don't know, we're 50-50, the tie in that case goes to the plaintiff and not to the defendant because the defendant bears the burden of proof. Let me give you some examples historically of affirmative defenses. One is a statute of limitations. So let's say I enter into a contract with Bob, and the contract says I'm supposed to mow his lawn for 10 weeks, and he prepays, we'll say, $300 for me to do that. And so I mow the lawn for 8 weeks, but I just don't do it the last 2 weeks. And Bob sues me for it. And you know what? There's all this evidence that is presented that I did not mow it those last 2 weeks. And honestly, I didn't mow it, so I don't want to perjure myself. So I admit, yeah, I didn't mow it those last 2 weeks. So it looks like I'm going to lose the case. I'm going to have to, the jury's going to rule in favor of Bob. But then I say, you know what, ladies and gentlemen of the jury, you're absolutely right. The plaintiff is absolutely right. I did not mow the last 2 times. But you know what? The statute of limitations for a breach of contract claim is 4 years. Well, Bob didn't file this lawsuit until 4.5 years after the alleged breach. And so even though clearly I breached, he waited too long to sue. And let me show you, let me look at the contract. You can see the date that it was signed. Look at the dates that I was supposed to mow the lawn for the 9th and 10th time. That's in the contract. And look at the date that Bob filed his lawsuit. Well, let's do the math and see, yes, that is after 4 years. Bob says, you know what, I agree. I can't disprove what she's saying. I did wait more than 4 years. Well, now under those circumstances, I can prove the affirmative defense. So a statute of limitations is an example of an affirmative defense. And of course, a statute of limitations would apply in employment discrimination cases or some other type of claim, contract claim or whatever. But let's consider not the statute of limitations, but the Ellerth affirmative defense. This is the one it's usually called the Farragher-Ellerth affirmative defense that applies in sexual harassment cases. This is what the employer has to prove after the jury has been persuaded that in fact there was sexual harassment, but there was no tangible job action. There was no termination or demotion or something like that. If the employer can prove this by a preponderance of the evidence, then the employer is off the hook. The employer doesn't have to pay. The supervisor still potentially is going to be on the hook, but not the employer. So let's see where the employer liability happens. No liability will exist if the employer exercised reasonable care to prevent and correct any sexually harassing behavior. So let's consider the term reasonable care. What does that mean? Reasonable in the law has a very specific meaning, and we'll see this term not infrequently in this course. And if you take other legal or paralegal courses, you'll see this term again and again. When you see reasonable, think objective standard. Think about not what one person quirkily thinks of as reasonable, but what the general society would conclude as reasonable. So, for example, reasonable care might be having a sexual harassment training policy. That might be a reasonable response. But it would probably be an unreasonable or overkill to require each employer to have a month-long program in sexual harassment avoidance. I mean, gosh, and all the employees would be required to go to this month-long training to be trained about sexual harassment. But let's just say that would be an unreasonable expectation to have relating to sexual harassment. There might be one or two people who might say, no, I think that's reasonable. But they're the outliers. They aren't the mainstream. They aren't how most people feel about this category. So when you see reasonable care, we're looking at what would an average, ordinary person think is a reasonable response in this situation. So the employer exercised reasonable care to prevent and correct any sexually harassing behavior. And the victim unreasonably, so this here we're talking about the same term, so now they are doing stuff that was silly, that was not under the circumstances what a reasonable person, what your average ordinary person would have said was a smart idea. The victim unreasonably failed to take advantage of any preventive or corrective procedures provided by the employer to prevent harm. So let's say an employer provides sexual harassment training, provides lots of ways that people can complain about sexual harassment training, and the employee suffers sexual harassment and never takes advantage of the tools. Well, quite possibly the jury would conclude that that victim acted unreasonably. But let's say that the sexual harassment program, in order to lodge your complaint, you have to take your complaint to your supervisor. And let's say the supervisor is the person who's harassing the victim. So the victim's only mechanism for complaining about sexual harassment is to complain to the person harassing him or her. Well, I think most of us say it wasn't unreasonable for the victim to fail to use the procedure because the procedure was stupid. It didn't address this possibility. Another way that a jury might find that a victim did not act unreasonably would be, let's say, that the victim knew of other people who had attempted to use the process that the employer has established to investigate sexual harassment, and as a result of their involvement in this, they were all fired. That would be an indication. The victim could say, wait a second, I don't want to get fired. I'm really concerned about retaliation based upon what I've seen. So the response of the victim not to file the complaint could be found to be reasonable. So it's important in this mode that the employer establish the program, train the workers in sexual harassment and prevention, and also have a reporting system, but to think through the various ways the system can break down. HR professionals and law firms are often very much involved in investigating these types of matters, in setting up the programs initially and then investigating them later on. And so you have to think through, imagine yourself 2 years from now in court trying to justify the choices that you made in designing the program, and being able to respond to allegations that there's a flaw in this program. You have to try to anticipate all of those ins and outs. The bottom line is that employers and employees need to be proactive in enforcing the policies. If you are the victim of sexual harassment and you're thinking about suing, you would be wise to attempt to use the sexual harassment program that your employer has. If you're an employer who's seeking to reduce the liability that you may have if sexual harassment happens in the workplace, you'll want to have a sexual harassment policy in effect. You'll want to have lots of different avenues and mechanisms to investigate it. You're going to want to have people who are very trained in how to conduct the investigations and how to avoid retaliation claims. So it's really a holistic approach. You have to think through it at lots of different levels. It's also really easy for that system to break down. And so it's something to keep in mind, to keep it well-oiled, well-functioning, working quickly, and working appropriately. So this whole system here that we've just been talking about, even though this is in the Ellerth case, is really called the Farragher-Ellerth affirmative defense. This is super important. Now, the reason that I talked about it here isn't so much that we're focusing on sexual harassment. Instead, we're focusing on a situation in which we are saying no vicarious liability. Here we go, because we're talking about this whole respondeat superior. So Ellerth is providing us, the employer, an opportunity to avoid the vicarious liability if we're able to prove this. And it's done specifically in the context of harassment. But we'll discover, we'll dive more into sexual harassment later on. So we're not really focusing on sexual harassment part. We're focusing on the vicarious liability part. This is a very important case. You do need to know its name and its holding with particular attention to the affirmative defense, and also to the area where we can't use the affirmative defense, because we can't use it here. We can't use it when there actually is a tangible job action taken. The affirmative defense won't work. It doesn't really matter whether the employer has all of these things going for it. The employer's still going to have liability. Okay, this next case it falls into the example situation. So you're not responsible for knowing this particular case, but I think it's an important idea for us to talk about. Again, we're going to talk about those 4 things we talked about before in each case. We're going to talk about the issue, the thing that the court is trying to decide in this case. We're going to talk about the facts. We're briefly going to talk about the procedural history, which is how the case has moved through the court system. And then we'll finally talk about the holding, which of course is the most important part. So our issue is, can an employer be liable for the actions of an employee who lacks decision-making authority? You know, we talked before about agency and how an employee is an agent, and we talked about the course and scope of the duty. And we also talked about a situation, well, what about an employee who exceeds his authority? And so this is what we're looking to here, when the employee is exceeding the authority. And we'll look at this particular fact pattern. We see here, Hill is our plaintiff and the employer is Lockheed Martin. So Hill worked, she worked as a mechanic. She received some reprimands, and because she had so many reprimands, she was ultimately discharged. She was replaced by somebody who was significantly younger and who was male. And so she felt like she had a good claim of discrimination. She, however, doesn't dispute these facts. She concedes that she violated Lockheed's procedures, and according to the procedures, she was in line to be dismissed. So her argument isn't Lockheed made this up or Lockheed was setting me up or anything like that. She agrees that the person who was administering the program was just following it just as it was designed to work, and if she had been a younger person or a male, it would have applied the same way. So what is her argument? Well, let's look at Ed Foltz here. He is the safety inspector in the workplace. It was Hill's opinion that Ed Foltz had a discriminatory animus against her. He wanted to get her fired. But Ed wasn't the boss. He was more along the lines of a peer, but he turned her in on some of these things, and he had this discriminatory motivation to turn her in. And he would report her to people who had no bad negative feelings about people who were older or people who were female, but Ed had these ideas. And so we call this the cat's paw doctrine. Now, in this case, Ms. Hill was not successful. The court concluded that Hill did not prove discrimination by the safety inspector. So her whole argument that Ed was out to get her, the court said, not enough evidence for that. And of course, the people that actually implemented the decision, the higher management, did not have any improper motives against her. But if the facts had played out a little bit differently for Hill, she might have been successful. Let's say she had been able to prove that Ed Foltz was discriminating against her, had a racially, or not racial, but gender animus or age animus against her. And he shared this information with more senior management who were innocent of any bigotry, but they believed what Ed told them. We call that the cat's paw doctrine, and it's important that you be aware of this because if an employer relies upon faulty information from a discriminator, then they kind of inherit that bias. And so even though they had no evil animus themselves, when they base their decision upon that animus, then their decision becomes discriminatory. We call that the cat's paw doctrine. Here's a bit of a definition. An employer's decision is discriminatory even if the decision maker was motivated by a legitimate concern. If the decision maker was relying upon negative information from another employee, like Ed Foltz, who was motivated by unlawful discriminatory or retaliatory animus. As a result, when you're making employment decisions or investigations, think about what's the motivation. Think about, you're saying this happened, but where's the evidence? Where's the paper trail? Where's the confirming documentation? Okay, let's talk about non-competes. Non-competes are a very interesting issue. Usually when non-competes in some jurisdictions are controlled by the common law, and in some jurisdictions are controlled by a statute, and some actual jurisdictions are controlled by a state constitution. In many areas of the law in the United States, there's a great deal of similarity in employment law. There are some differences, certainly. California tends to be an outlier. Wisconsin and New York tend to be a little bit of outliers. But probably 35 of the states are pretty similar with one another. And Texas is in that mix with the majority of states. But there's one area of the law of employment law where there's just a tremendous amount of variation. And you can't easily say, you can't easily group things because really things are spread out over a continuum. And this is the area. Non-competes, also called covenants not to compete, or restrictive covenants is another term for it. There's actually several different terms that we have here. So let's first of all define what a non-compete is, and then we'll talk about what the options are, what states can do in this area, and what Texas has chosen to do in this area. So what is a non-compete? A non-compete is an agreement by an employee not to disclose the employer's confidential information or enter into competition with the employer. This is probably the more important part. Enter into competition with the employer for a specified period of time and or within a specified area. Now, this is written as if the only type of non-compete people ever enter into is an employment-related non-compete. But that's not true. There are other types of non-competes, but of course this is an employment law course, so we're focusing on this niche. I just want to share with you that there actually can be other types of non-competes. As I said before, states vary wildly in this area. California prohibits all non-competes. It's actually in the state constitution. And that's one of the reasons some people opine that Silicon Valley has been so successful. Because if I happen to have a great idea, and I'm an employee in Silicon Valley, I wake up in the middle of the night and I think, wow, that's a better way of doing X. Well, I go into work the next morning, I quit from my job, and I start my own business, and I'm making, gazillions of dollars in 6 weeks, and I sell my business to somebody else, and that happens again and again and again. If non-competes were permitted in California, probably most of those businesses would have their employees in non-competes. And so therefore, when I woke up in the middle of the night with that great idea doesn't belong to me, and it belongs to my employer. And so I don't have that luxury of starting my own business or taking that idea on my own. So having or not permitting non-compete, some people say, helps increase innovation. But there are downsides to it as well. So California is really the unusual state in our group. They don't permit non-competes at all, and they won't enforce non-competes from other states. So if you are in a non-compete that you want out of, just move to California. Problem solved. May not fit your lifestyle, but it will get you out of your non-compete. Other states, some states like Missouri, are very open to non-competes. They will enforce the vast majority of non-competes unless it's really, really, really onerous. They kind of start from the process of freedom of contract. I think we talked about earlier. Let me actually go back and flip through those. We talked about the advantages and disadvantages for here, the various views, and we talked about, let me actually go back a little farther. We talked about the freedom to contract, and one of the things that states that are more open to enforcing non-competes, they say is, look, nobody made the employees sign on the dotted line. If he didn't want to sign, he shouldn't have signed. He knew he could read the words. We're all grown-ups here. Don't sign stuff you don't want to be bound by. That's the argument in favor of enforcing the non-competes. The market will work to encourage employers making rational, non-biased decisions, and employers ought to have the freedom to make those decisions. At least that's the argument. And so that's the position that many states have taken. Obviously, it's not the position that California has taken. So where does Texas come down? Generally speaking, in the employment law area, Texas is definitely on the conservative end of things. I wouldn't say it's the most conservative state, but it is certainly on a continuum closer to being a conservative state than a liberal state. But Texas is very much middle of the road, which puts it in a more, again, not as liberal as California, not as pro-employee as California, but certainly a more pro-employee than average. The way I like to phrase it is Texas will enforce some non-competes, but there's lots of non-competes it won't enforce. The language of the statute isn't so telling in this area. If we were to go back into a time capsule and it was 2000, I would probably be teaching this section pretty differently. I'd be saying things like this. You know what? In Texas, we have a statute that pretends non-competes can work, but courts never enforce them here. They always find a loophole to not enforce it. So good luck, employer, if you want to enter into a binding non-compete in Texas, because it's pretty darn tough, and I don't really have a good path to tell you how to do it. But that changed in the 2000s. There were several cases, 3 or 4, that went to the Texas Supreme Court, that even though the statute itself hadn't changed, the courts were interpreting the language a little bit differently. Now, they didn't overrule any previous precedents. They acted like everything was consistent, but not so much. I mean, they really were moving the ball in terms of where the law was. Sheshanoff was a big case. Several other cases came down the pike that have evolved the law. And so now it really is possible to enter into a non-compete in Texas and to have a pretty good chance, if you're careful as the employer, to having it be enforceable. It's not as easy as it is in Missouri and a few other states, even some states that are fairly liberal, but it is doable. It is now an obtainable goal. And this really this change in the law, and it's still evolving to some extent, this change in the law is not due to statutory change, but is due to the change in the perspective of the Texas Supreme Court. So here's our statute. The statute itself is quite typical. It's not extraordinary in any sense. Let's start right here. A covenant not to compete is enforceable if it is ancillary to or part of an otherwise enforceable agreement at the time the agreement is made. To the extent that it contains limitations as to time, geographical areas, and scope of activity to be restrained that are reasonable. So we need 2 things in Texas. We need it to be part of an otherwise enforceable agreement. That's the first part. And the second part is it has to be reasonable in terms of time, geographic area, and scope of activity. This part here you're going to find in virtually every statute that deals with non-competes, that these have to be reasonable. Now, what courts have decided is reasonable, what's not reasonable, has varied, of course. We're seeing that word reasonable again that we talked about before, that has to do with, kind of generally acceptable norms in our society. And so you might have a more conservative court say, well, a larger geographic area is reasonable than maybe a more liberal court. And it's going to turn a lot upon the industry. Let me give you an example. It's very common in the hairstyling industry for the hairstylist to sign non-competes. And so they're going to have limitations. But think about it. Very few people are going to travel significant distance to get their haircut. I mean, if my hairstylist moves to Houston, I'm not going to get my hair done down there. I'm going to get a new hairstylist, right? Now, if my doctor moved to Houston, I might consider going to see my doctor down there if I'm having some serious medical issue. But for hair, I don't think I'm going to make that much of an effort unless maybe I'm a model or somebody who makes her living based upon her appearance. So you would look to geographic area depending upon the particular industry. The time. Let's say I am a John Deere tractor salesperson. Well, my customers might, on average, buy a tractor from me every 4 or 5 years. And so as I've dealt with them, maybe I've worked in this particular region for 20 years, I kind of know when farmer A is going to need a new tractor and when farmer B is going to need a new tractor. I have the information. I may not call upon farmer A for a couple of years because I know this isn't the right time for him. But when I think, yeah, that tractor he's been using is probably about done, that's when I'm going to go drop in and see him. I might occasionally drop in just to keep the connection going, but I'm mainly focused on when he's going to need me. Well, let's say I leave the employee of John Deere and go to work for Peterbilt. If I take all that information with me that I've developed by being a John Deere salesperson, I'm going to still know exactly when to visit that a farmer to maybe sell him a Peterbilt tractor instead of a John Deere tractor. So you could see in that situation, the time of a restriction might be significantly longer for looking at tractors. compared to hairstyles, because the reality is most people are going to get their hair cut, every 6 weeks, 8 weeks. Certainly you would expect that somebody after 6 months would have gotten their haircut somewhere. So a non-compete that restricts you from competing in the market for 5 years seems pretty unreasonable, because nobody's going to go 5 years without getting a haircut. Or if they did, they weren't a regular customer of yours before then. So you have to consider the nature of the business. Let's consider the scope of the activity. Again, going back to the hairstyling situation. There are certain types of hairstyling procedures that might all kind of be bundled together. For example, cutting the hair, giving permanent waves, putting relaxers on hair, dyeing hair, putting highlights in hair. All of those activities we might think of as hairstyling things. And so it would probably be reasonable to restrict one from doing all of those categories together. But that same hairstyling place might also do nails or give massages. Those usually are not considered the same type of service. And so let's say I decide to get out of the hairstyling business, but I decide to become a masseuse, and I might work at another hairstyling place, but performing massage functions there. You could argue that that would be a different scope of activity, and I shouldn't be restricted from doing that. So those are the types of things that you need to think about as you are deciding how restrictive or how broad it is. Now, you might be thinking to yourself, well, if you're an employer, you want to make these super broad, right? I mean, that's a smart strategy. You want to maintain as much control over your employees and make it as least desirable as you can for them to jump employment. There is an argument for that, but there's a few arguments against that. I guess the first argument is kind of a humanity argument. You probably aren't going to be the best, the most sought after employer if you mistreat your employees, right? So just from an informed business perspective, being a jerk about non-competes is probably not your go-to strategy. It's not nice, number one, but number two, the word is going to get around that you're a jerk in this area, and you're not going to be attracting the best folks. The second is that if you overreach, if you ask for the sun, the moon, and the stars, the court may well not give you anything. The court may look at your document and go, you know what, it's 100% unenforceable. I'm not going to rewrite it and make it reasonable because you so overreached. You're just not even worth. You don't deserve me to pull it in a little bit. Now, sometimes what courts will do when they get a non-compete that is unreasonable, but it's pretty close to the line, is they might just tighten it up. For example, let's say the geographical area was described in the contract to be the state of Texas and 10 counties in Oklahoma. Well, maybe the court concludes, I think the 10 counties in Oklahoma is overreaching, but not overreaching by much. So I'm going to reform or rewrite this contract and exclude the 10 Oklahoma counties. On the other hand, if the employer had said, oh, the scope of this restriction is the 48 connected states, the court would be like, wait a second, that's completely unreasonable given the fact that this particular employee was only dealing in Texas and maybe a little bit in Oklahoma. The court isn't going to say, this is major overreaching, I'm just going to throw the whole thing out. And so you don't want to be in that situation. Now, I'm going to be honest with you, though. There is an argument for overreaching. There is an argument. I'm not defending this, but in the interest of full disclosure, I'm going to tell this to you because there is an argument for employers to overreach in the area. Sometimes employers will ask for maybe not the sun, the moon, the stars, but maybe the sun and the moon. And the logic here is we don't know that we'd win the case, but what we do know is the employee is thinking we might win the case because the employee is not very sophisticated. And even if the employee is sophisticated enough to recognize that there might be some overreaching, the employee doesn't have the money to hire an attorney, a sophisticated attorney in this area. And so we're going to be able to outlawyer this person. Plus, even if this employee is very sophisticated and has the means to hire an attorney, the reality is if he leaves our employee to work for somebody down the street, we send a cease and desist letter to the other employment opportunity. They don't want a lawsuit. I mean, this is a new person on their payroll. They're not really invested in this person. So most likely what they're going to say is, hey, look, buddy, we don't know if you've got a good non-compete or not. What we do know is we don't want to pay $100,000 in legal bills to keep you around here. So goodbye. Good luck, but we're not buying this lawsuit. We don't want to participate in this. So sometimes a non-compete that overreaches can be enforceable. Is that ethical? Is that the way you want to play this game? I would hope not, but that's the way sometimes people do play the game. So in the interest of full disclosure, I wanted to share that. Okay, so we've talked about how the terms, and this is really in any state, not just Texas, they have to be reasonable in terms of the scope, geography, the scope of activity, and the number of years. Generally speaking, 2 years is kind of a reasonableness standard, and usually the borders of a state are a fairly reasonable standard. If the person were, say, a salesperson or something along those lines, usually the geographical limits of his or her territory is a good way of approaching it. When you draft a non-compete, or when you seek to have an attorney draft a non-compete, it's a really good idea to include in that what's called a forum selection clause. Again, this term is in red, so pay attention to it. It's an important one. A forum selection clause is a clause in a contract. And of course, a non-compete ultimately is a contract, or at least part of a larger contract. And this clause says, listen, this is the law that we want to apply. This is the state law we want to apply. Usually states are going to enforce that clause. So let's say, I'll give an example. Let's say that I enter into a non-compete in the state of Missouri, and it's a very pro-employer non-compete. I take a job in Texas. The non-compete I have has a choice of forum of Missouri. It's very possible that the state of Texas will enforce that Missouri non-compete, even though it might say, gosh, that non-compete, if we were enforcing Texas law, we would not enforce this. But we agree under Missouri law, this is an enforceable agreement. So sometimes courts will, if they're instructed to do so by a forum selection clause, will apply another state's laws, even if they conflict with the laws in the state that the case is actually going forward. Of course, sometimes courts say, we can't do that because it really violates the fundamental public policy of our state. That's what California has done in this area. So that's why I said you can always move to California, even if you have a forum selection clause that picks Missouri or Texas or some other state. Because the California court will say, it's against the public policy of the state of California to enforce a forum selection clause in a non-compete in such a way that would allow the non-compete to be enforceable. So it is one strategy, one tool you have in your arsenal that can help. So if you are thinking to yourself, well, maybe Texas law isn't the most favorable for, let's say you're on the employer side, then you might want to consider a forum selection clause. These work best if you have some connection to the state. In fact, they're really not going to work at all. So let's say that it's a Texas company and it's a Texas employee. Well, guess what? Texas law is going to apply. You can pick the forum selection of Missouri, but no court's going to say, well, what's the tie between the employee and the employer to the state of Missouri? If there isn't one, the court's going to say, nope, Texas law applies. But if the employee was, say, a citizen of Missouri prior to the employment relationship, or if the employee is going to work in the state of Missouri, or if the corporation has its headquarters in Missouri, or it's incorporated in the state of Missouri, those are factors that might permit that forum selection clause to appropriately be the state of Missouri. So you'll want to shop around and figure out how that goes forward. Forum selection clauses are really, really common in contracts. Let me give you an example of one that I did once. I had a discrimination case. It had arisen it was a state law claim in a different state. And one of the provisions that we wanted to have, that my client wanted to have, was that they wanted to buy the silence of this particular former employee. They were concerned that if the employee started telling other people, hey, I got $5,000, that suddenly the employer would have lots of other people who would be making claims of this type, and so it could become quite a bit more expensive. So what the employer wanted was a confidentiality provision. We were going to pay the employee $5,000, and then we were going to say, but don't tell anybody. And if you do tell people, and the confidentiality provision wasn't tricky, but the next part's the tricky part. And if you do tell people about this, you're going to have to pay us back $2,000. And you know what? We, the employer, don't have to prove that we were harmed $2,000 worth. It's what's called a liquidated damages provision. It's an automatic provision in the contract that says you have to pay us this amount of money even if we can't point to any direct loss. And the reason why this clause is useful is it's a lot of times hard to prove direct losses because of breaches of confidentiality agreements, because lots of people might file lawsuits. It's hard to know, well, which ones were filed because this person didn't keep the secret. That's really, really hard to prove. And so the liquidated damage provision motivates that former employee to keep his mouth shut and hopefully accomplishes that task. What the employer wants is not so much to collect the $2,000. In fact, that's a bad outcome. The employer really just wants the employee to stay quiet, and this is the motivation for that. Well, anyway, we entered this agreement for $5,000 with a requirement that the employee remain quiet. But in this particular state, that liquidated damage provision was unlawful. And so, easy problem to solve. My client was a Texas corporation, so it was reasonable for us to choose a forum selection clause that provided that Texas law controlled. These provisions are perfectly lawful in the state of Texas, and so we just said Texas law applies. And even if the employee were to file a lawsuit in Ohio about it, the Ohio court would probably agree that Texas law can apply under those circumstances. But as a practical matter, more likely it would be the Texas corporation that would be suing the employee. And so the Texas corporation could file the lawsuit in Texas, and of course the Texas court very likely would apply Texas law. So that's a strategy to increase your chances of winning in these matters. Okay, so when do we get to use a non-compete? First of all, the purpose of a non-compete is not to frustrate the free enterprise system, not to undermine capitalism by having this monopoly. It's an unfortunate aspect of non-competes that a monopoly is created. I can only work for this one employer in this one industry as long as I'm in this non-compete. And so it does have some anti-competitive implications. And that's something the law generally doesn't like at all. So we need to have a particular reason to even entertain the idea of a non-compete. We need to be able to point to a legitimate business interest in order to be successful. A legitimate business interest might be keeping the secrets or the training advantages that might accrue to that business. If I work for John Deere and I'm gathering all this data, and then I go to Peterbilt and say, hey Peterbilt, I know all of the farmers in this region who need a new tractor. I have all of my database that I've meticulously prepared as I've been an employee for John Deere. I'll bring that all with me if you'll hire me to sell your tractors. You can see how that wouldn't be fair to John Deere. The employee that it was trusting is now stabbing it in the back. And so it has John Deere in those circumstances has a legitimate business interest in stopping me from doing that. Let's say that I'm on a cutting edge technology team. And so I'm hearing all of these cutting edge ideas, and one idea builds on another idea, builds on another idea, and so forth and so forth. And so I have all these ideas that I have developed and worked on and learned from in this professional experience at this particular employer. If I can just take all that wisdom and bring it to my next employer, you can see how that's really not fair for my first employer. So that's another example of an employer having legitimate business interest in not having me enter into a relationship with a competitor. Now we're going to switch gears just a skoonch and talk about trade secrets. Trade secrets oftentimes are in play with non-competes. That's one of the categories of legitimate business interests that can cause an employer to be able to use a non-compete. Let's look at the definition of trade secrets. Again, it's one that's in red, so you want to pay particular attention to that. A trade secret is information that has value, in part because it is held confidential and a company takes reasonable steps to protect it from disclosure. Things that could qualify as trade secrets would be the 11 herbs and spices in Kentucky Fried Chicken or the formula for Coke. Those are examples of trade secrets. You might think, well, what's the difference between a trade secret and a patent? When you seek a patent, you have to disclose all of the secrets about it in the patent application, or you can't get the patent. But when you have a trade secret, you are going to keep it a secret. You aren't going to let anybody else know, because as soon as it's known by the general population, the trade secretness of it goes poof. It's no longer a trade secret. So a trade secret is only a trade secret until somebody outside the organization knows, and that's why you have to be so careful about it. So sometimes a corporation has a choice. They can either go the patent route or the trade secret route. The patent route has some advantages. You can sell the ability to use that patent to license it to other people. Trade secret, you can't really do that, because then of course you'd be revealing the trade secret. But a patent does expire at some point, 20 years after it's been issued. Typically it was 17 to 20 years, depending upon the circumstances. But a trade secret can literally last forever, or it could vanish like that if it is revealed. So sometimes it's a call. Sometimes corporations use trade secrets because whatever is the trade secret isn't a patentable type thing. For example, recipes can't be patents. A customer list can't be patents. So some of the data is not going to be patentable. When you have a trade secret, that's a good reason to go ahead and have your employees enter into non-competes, or at least non-disclosure agreements. So going from trade secrets, let's talk about inevitable disclosure. Okay, let's look at what this theory is. And let's first of all just break it down. Disclosure, we know what that means: to reveal something. Inevitable means it's going to happen. There's no way we can stop it. So inevitable disclosure basically means some secret is going to come out and there's nothing we can do to stop it. That's the kind of underlying meaning. Let's look at the official definition of the term. The theory under which a court may prohibit a former employee from working for an employer's competitor if the employer can show that it is inevitable that the former employee will disclose a trade secret by virtue of his or her position. This doctrine can be used even if there is no non-compete, even if there is no non-disclosure agreement. So if I am in a position where I have these secrets, and then I want to work for a competitor, and I don't have a non-compete, my employer can still possibly stop me from doing that under this doctrine, inevitable disclosure. So here we continue on. And a court may prohibit a former employee from working for an employer's competitor if the employer can show there is an imminent harm that a trade secret will be shared. Now, courts don't apply the inevitable disclosure document when there isn't an underlying non-compete frivolously. There needs to be some pretty strong facts, because again, the idea of freedom of contract and things along those lines are really important concepts. Let's look at a case that has applied the inevitable disclosure doctrine. So we're going to flip to slide 92. Again, we'll see this same pattern that we saw before. We'll have an issue, we'll have some facts, a little bit of procedural history, and then we'll have the holding. So what is our issue? Should an employee, in this case we've got Redmond is the employee, should an employee be enjoined, read this, to be stopped from working for a competitor, Quaker Oats, when it is reasonable to assume that the trade secrets of the former employer, PepsiCo, will be inevitably disclosed to the new employer? And the answer this court came up with was yes. So Mr. Redmond, the person who Pepsi is suing, was pretty high ranking, and he had access to all kinds of secret information about Pepsi's business plans. He had signed a confidentiality agreement with Pepsi, but he didn't have a non-compete. He quit Pepsi to go work for Quaker Oats, which was a competitor. Quaker Oats at that time owned Gatorade. And so Redmond knew what Pepsi was planning on doing in that sports beverage industry. And so having that information was really going to give Redmond a lot of ability to make Gatorade highly competitive. So they knew what the plans were in terms of the flavors and the pricing and distribution and all that kind of stuff. And Redmond, unless he got hit on the head with a coconut, a la, the Gilligan's Island, he was going to know that stuff. He wasn't going to be able to forget it. He just knew it. And so every time he made a decision at Gatorade, the background noise in his head was, and this is what Pepsi's plan is, so this is how Gatorade's plan is going to intersect with Pepsi's plan. Anyway, PepsiCo recognized this fact that Redmond had this information, and so PepsiCo was trying to stop Redmond from working at Quaker Oats because of this conflict. It just so happens that while this lawsuit was progressing, PepsiCo bought Gatorade from Quaker Oats. Kind of a funny deal there. But the court ultimately agreed with PepsiCo and said, yep, Redmond, you can't work for Quaker Oats. You can't forget what you know, and that's going to cause Pepsi too much harm. It's kind of a sad story for Mr. Redmond. I hope he ended up doing okay. Okay, so we are now going to return to where we were before, and we're going to go through a couple of scenarios. Mary works as a chief chef at this restaurant. The management changes, and so she's asked to sign a non-compete in order to keep her job. The non-compete required Patty, I'm sorry, not Patty, it should be Mary there, I apologize, requires Mary not to work as a chef for any restaurant or open her own restaurant in the United States for the next 15 years if she decided to quit her job at the current restaurant. A Texas court is just not going to enforce this. For one thing, it doesn't seem to be ancillary to an agreement because there's no additional consideration for this. She was already employed by this particular place. So the first requirement doesn't seem to be met, and the rest of it doesn't seem reasonable at all. 15 years is really, really outrageous. And it was for the whole United States. So again, just not going to be enforceable. I don't think that one will be enforceable anywhere. Okay, let's consider the next scenario. Carl was employed as a chief architect at this particular company. He signed an enforceable covenant not to compete when he was hired 2 years ago. The agreement states that Carl cannot work for a competitor within Texas for 1 year if his employment ends. Carl's employer finds out that Carl's been doing temporary part-time work for himself in the architectural business, and therefore, of course, the employer fires Carl. Carl now wants to work for this other business in Frisco, so it's within the state of Texas, and it's still within that 1 year period of time. Carl cannot take up the new job if the location and time restrictions in the not-to-compete agreement are deemed to be reasonable by a court. And I think it's quite likely that under these circumstances, the court would find that they're reasonable. It was within the state of Texas. It was for 1 year. And it's in the same industry. So it seems pretty reasonable, I would say. Okay, in Texas, we have not passed the Uniform Trade Secrets Act. Texas is only one of 4 states last time I checked, so we're kind of an outlier in this area. It doesn't mean we don't have protections for trade secrets. It means that we rely upon the common law protections. Again, common law has to do with judicial decisions. We don't have a statute. Our state legislature hasn't acted in this area. But again, when the state legislature hasn't acted, what happens is the decisions made by our court system are what control. And they will remain in effect until the time that our legislature does choose to act. And then the legislature's laws will replace that common law insofar as they conflict with what the common law says. And so we have all those judicial decisions in place designed to protect trade secrets. So don't be worried about it. We've got a good deal set up here. Because we don't have the Uniform Trade Secrets Act in Texas, I'm not really going to focus on the ins and outs of this particular statute. As you see the blue asterisk, you're not responsible for this information. I've already talked about the Redmond case. Okay, and so now we're at the end. We're going to talk about some big issues. I'm calling them boulders here that you ought to keep in mind as we end this particular presentation. First of all, this is again from the first lecture, it's really important to get this right between employee and independent contractor. If it's on the line, if you're not sure which category it is, the safe bet, the cautious way to proceed is as an employee. If you mess this up, bad things can happen to your employer and to you personally as a career move. And so err on the side of caution in this area. You have to be careful about non-competes and non-disclosure agreements in Texas. They can be enforceable, but they're not going to automatically be enforceable. It's important to be using a Texas-specific employment attorney who knows this area very, very well. Well, we're done. We're done with our first module in this course. I hope this has been interesting and helpful for you as you prepare for tests and assignments. It's been my pleasure sharing this with you today. I hope you have a wonderful day. Thanks for your attention. Of course, as always, if you have questions, be sure to email them to me and or come by my office hours, and I'll be glad to field any questions that you might have. Thanks again.